and gentlemen, we're at the end of this case, and we're going to be presenting to you the law and all of the facts showing why you should find this defendant, Susan Embert, guilty of all the charges that have been brought before you in this indictment. Susan Embert, as we told you in the beginning of this case, needs to be held responsible for what she did. She's responsible for murdering Jake Embert. She murdered him. And she set the scene up to make it appear as if he supposedly killed himself. She murdered him. Now, ladies and gentlemen, what you need to understand is that a trial is a search for the truth. A trial is a search for the truth. And we're having this trial to show the truth of what this defendant did. And you have certain tools that you use in the search for the truth. And one of the things that you begin with in finding the truth, you use those tools. To begin with, the arguments, objections, questions of lawyers is not evidence. That is not evidence. That is not evidence. You have certain things that are evidence. We're going to go over what those things are. Things that you use to evaluate a case. Generally, there are 4 different types of evidence. There's physical evidence, such as an item itself, such as the gun, that was used to kill Jake Embert. This is an example of physical evidence. The other type of evidence, ladies and gentlemen, includes documentary evidence and demonstrative evidence. And the other thing, ladies and gentlemen, that is evidence is testimonial evidence. Testimonial evidence. That is testimony that comes from witnesses in court. And the testimony of any one witness can establish a fact. So the 4 forms of evidence are physical evidence, documentary evidence, demonstrative evidence, and testimony. Testimony is evidence just like this piece of physical evidence. Those things are all evidence. So, ladies and gentlemen, how do you use evidence? You use evidence by weighing the evidence. You weigh the evidence. And the statements of the defendant, if you do not match the evidence, may be rejected by you. And I'm going to talk about that further as we move along. So, ladies and gentlemen, there's different ways of handling evidence. There's direct evidence, and I'm going to just go through these ideas. I'm moving ahead of my slides. But direct evidence is where you have a witness that said, I saw something. Directly going to an issue or fact. Direct evidence. And there's circumstantial evidence. Again, using that process, you look at all of the physical evidence all of the documentary evidence, all of the demonstrative evidence, and all of the testimony. And when you put all of those things together, and you put them together with what we call all of the facts, that is using circumstantial evidence. Putting together demonstrative evidence, physical evidence, documentary evidence, testimony, plus what you call and what we know to be your common sense, common experience, common observation, and common knowledge. Putting these things together is when you're using circumstantial evidence. And we're going to give you more information in the course of the state's argument, because again, at the point that you were beginning on the evaluation of the evidence, you will have an understanding of what the law is. So, in this case, and in any case, the state always has the burden of proof. The state has to bring you any of the evidence in the general forms that have been described in what you would be using. And the defense has no burden whatsoever. The defense does not have to prove anything, and the burden never shifts. It's always the duty of the state to present the evidence. And ladies and gentlemen, the defense can say anything they want without having to prove it. They can make any kind of base assertion, any kind of base claim, send you on rabbit trails. They can do anything they want without having to prove it. And when I finish and the defense comes up next, there are certain things that I think you can expect. But again, remember that the questions, objections, and arguments of lawyers is not evidence. But I anticipate that the defense, as based upon everything they've been doing in the course of this trial, will argue that the investigation in this case was so poor that you should just let Susan Embert go. And they'll argue that we can't show it was impossible for Jake Embert to have killed himself or chosen to take his life. That's what we anticipate they're going to argue. Now, to begin with, as I mentioned to you, the defense can say and do anything they want. I can tell you some of the rabbit trails they've already sent you on as far as this case. We went through all of that dialogue about what the coroner did. And ladies and gentlemen, what the coroner did or did not do in his ministerial work, changing his documents, has nothing to do with what this defendant did. Ultimately, the decision about what she did is in your hands. So what the coroner did and all the rigmarole we went through about what the coroner did and his paperwork, all of that has nothing to do with anything. We went through the rigmarole about right-hand guns and left-hand guns. That has nothing to do with anything. It's a rabbit hole of time wasted, and I expect they'll keep talking about that. But that's another waste of your time. These things are things that we can anticipate when they come up. They're going to be talking about that, and you should ignore it out of hand because, again, it is a waste of your review. These things have nothing to do with the evidence that is presented and the decision that you have to make. So, ladies and gentlemen, do not waste time going down the rabbit trail of things that have nothing to do with the issue of what Susan Embert did in your evaluation of it. You can expect they'll say that the investigation did not have everything that can be done. Ladies and gentlemen, it is not the law. The police are not required to do everything that's possible to be done. Does that mean that a defendant should go free when there's evidence showing sufficiently what they did do? No. It does not mean that. And the other thing is not the law, and you won't hear the judge say this. The judge won't say that if the police don't do everything that they could possibly do, and there's a billion things that can be done. You've heard all the things that have been done in this investigation. We talked about it. We've acknowledged that this investigation could have been done better, more thorough. There's no doubt about that. But what is the truth is that ultimately, if there's sufficient evidence that is gained, which it was in this case, you have sufficient evidence to return a guilty verdict, and you should. The other aspect of this situation is that the law does not require that it be shown that it was impossible for things that have happened. What the court will tell you, reasonable doubt is a doubt based upon a reason. And there can be any possible thing that could be happening. A lightning bolt could strike anybody. Anything could happen. But what is reasonable based upon the facts and the evidence is what you're making your decision on. The other aspect of this situation is that the law will be that if there's sufficient evidence, you don't have to be reasonable. The state is not required to prove everything to 100% mathematical certainty. That's not the law either. And that's what you hear from the court. Those three ideas. Number one, that the law requires that the police do everything that's possible to be done. The law does not require that it be proven that it was impossible for the defendant not have done this crime, or that you must be 100% absolute certainty. The only people that are 100% absolutely certain about this situation are Jake Embert and this defendant who did what she did. She's certain what she did because she was there and she did it. But you as jurors, if you have reasonable information, you have sufficient information, which we have shown overwhelmingly in this case, you should return a verdict of guilt based upon that evidence. And ladies and gentlemen, all the defenses I think they will try to argue, they don't have a burden, they don't have to show you anything, but they all fail. All of their arguments will fail. So ladies and gentlemen, I want to talk about one aspect of this case that seems to be, again, the effort by this defendant to mislead the world about what she did. Suicide. Suicide, the choice to choose to take your life, to choose to end your life. Now the thing about that is, anybody can decide to choose take their life for reasons that maybe have nothing to do with mental illness or sickness or anything. They can consciously decide to choose to end their life. And the thing, like, if you remember your history, during World War II, some Japanese pilots, they decided that, to fight the American Navy, what we'll do, on behalf of the Emperor, I choose to kill myself and crash into that ship. I choose to do that. Or even more recently, you see all the time in the news, in the Middle East, suicide bombers. They choose to end their life. You can make a conscious choice to end your life. Now, just because you may be on some medicine does not necessarily mean that you lose this ability to make the choice to choose not to live. And I suspect that the argument is going to be that Jake Embert had a lot of medicine in him, but everybody that's been given medicine, the medicine is to help. What do you really believe that everybody that is taking medicine, mental health medicine or depression medicine, any type of medicine, is going to go out and commit suicide? No, because they have not chosen to end their lives. I anticipate that this courthouse is full of people right now. Whole courthouse. Everybody in here, somebody might be using some medicine that could potentially say, it could cause suicidal ideation and choose to end their life. But that choice is being made. And in this instance, ladies and gentlemen, Jake Embert did not choose to lose his life. Susan Embert chose to end his life. Jake Embert did not choose to end his life. That was a choice made by the defendant. And ladies and gentlemen, look at all of the things that Jake Embert had going on at the time. And you must consider this issue. And this is all part of the totality of the case. Jake Embert was, on the date that he died, when she chose to take his life, he's planning on an adventure with his son, who he has loved. They're going to go to the races, which he's literally been working on the car and the race for days, weeks, before that Saturday morning. Now, to consider the timing of that, I choose to end my life right at the moment that I've been working for with my son, whom I love. I'm going to choose to end my life in a manner that most hurts my son that I love. Jake Embert did not make that choice. He did not plan to choose to end his life at that moment. All of the circumstances of this case, and ladies and gentlemen, you must look at all of the circumstances of this case and all of the events surrounding this case to make your decision. And everything that you've heard about Jake Embert, everything that you've learned about Jake Embert, shows you that he did not choose to end his life on that day. The other thing about that, there's no suicidal ideation from Jake Embert. Everybody that was associated with Jake Embert who came in to testify, who knew Jake Embert came in to testify, everybody says that Jake Embert did not choose or would not choose. They don't believe he would choose to end his life. Now, these are people who are looking at him every day. His family, his friends, everybody. His doctor saw him 2 days before the death. 2 days before the death, and he testified no suicidal ideations. If I'd have seen it, I would have done something about it. You heard that testimony. 2 days. And so on this most important day, you know what? I think I'm going to just get up, have some coffee, and then shoot myself. No. All of the circumstantial evidence surrounding Jake Embert, all of the evidence that you heard shows that that is unreasonable and unlikely and not the truth. What happened is she chose that morning. Jake Embert did not commit suicide. Jake Embert was murdered. So let's talk about different aspects of this case. One thing about this case is motive. Now, the state does not have to prove motive, and that is we don't have to show you what's actually in the mind of an individual that commits murder. We can't look into anybody's head. But all of the circumstances surrounding this case shows you exactly what's going on with this situation. Let's begin with the notion of how did Susan Embert get into Jake Embert's life. He literally picks her up from wherever she was, bags her. That's all she got, right? She got clothes on her back. That's all she brings. She embeds herself into Jake's life. Never left. Takes over everything. She takes over everything, including getting all of the insurance policies, all of the retirement policies, all of the bank accounts. Everything is over to her. Everything. Everything is brought over to her. This is now mine. This is what she's saying in her mind. And that's what we say the motive is pretty clear. This is mine. I have a house. I have steady income. Jake is a great find for her that she found on the internet. Jake, I guess everybody said what a good-hearted man he was. Well, that's a mistake he made. And ladies and gentlemen, there were the problems through the marriage. You heard from her statement, she wound up, they were calling the police on each other. You heard that. But the thing, moreover, about the motive is, now that she's embedded in his life, and now she has this potential to have property, to have a home. She's an older woman now with whatever bill she had and nothing else. She's not willing to give that up. So the situation sort of morphs as the notion is that as she is now relying upon Jake's income, Jake's finances, and where does the money go? Where does the money go? You heard all of the information about, well, where's the money going? The money's coming in. Where's the money going? Where's the money going? The money was going, as the evidence suggests, to Susan Embert's bills. She's supporting her mother. She's on the internet, probably running up bills during that. All of the evidence suggests that she's raking in and using money for her own purposes. Even the money that's used to maintain the household. That's why she became unhappy. She calls up Miss Magnus. I'm unhappy with Jake. I'm unhappy with this money situation. She calls the sister up to tell her that. So obviously she was unhappy. But now she got a hold on his accounts. Now moving forward, this thing is sort of like they call them a Russian doll. One thing is inside of another. And the motive still moves forward as you contemplate that she thinks she's got a good deal here. Jake, because of his heart attacks and any other ailments, he won't last long. He won't last long. And that's part of a mantra. But then part of the situation deteriorates where they fail to pay the bills that they need to pay. It's to the point now that the house is being foreclosed on, and now this situation is critical for her. Jake is more valuable to her now, dead. He's more valuable dead than alive. And that's pretty clear. She thought that she was going to get a big insurance payout. She got an insurance payout. But Jake is more valuable to her dead than alive. Now, fast forward. We get to the point where they are having the big blowouts. And the notion is that I can't let Jake leave me. I can't let him leave me. I can't let him divorce me, because if he divorces me before he dies, I don't get any money. If he divorces me, if he leaves me, if we break up, that's why Will was asked Daddy, are y'all gonna break up? Are y'all gonna break up? Jake at that moment, no. But moving forward, within that week, you heard she's now engaging in trying to sell Jake's stuff behind his back, engaging with Mr. Buckner. And now she's in a posture where if Jake finds out about what she's doing with Mr. Buckner, he's going to kick me out. So she's got a timeline now. A timeline based upon the foreclosure, which she knew about because she's the one that controls all of the mail and all of the information coming in. She controls that. So
Objection, Your Honor. Facts not in evidence.
Your Honor, there was no testimony that she knew about the foreclosure.
Just rephrase, Mr. Edwards.
Your Honor, I think the circumstantial evidence shows that she was aware of the foreclosure, and I stand on that. The jury will remember, is what I would respond to the objection.
All right. The jury will remember exactly what it is that was testified to in the case. Go ahead, sir.
She got a timeline. She got a timeline. And Jake is not dead. And Jake is going to find out about what she's been doing and may put her out. And again, she's lost what is now hers, which she claims, house. And she immediately, after Jake is dead, exercised all of that control over everything. Locks change on the house. Locks change immediately. This is mine. The Jeep is mine. She gives it to somebody in her family. The furnishings, this is mine. Everything is mine. There's premeditation all over this case as far as the murder itself. Consider the 911 call. In the 911 call, you cannot fail to see that she had a planned response when she made the call. She had a planned story that she got out. He's gay. He's got STDs. He's got this. He's doing all of that. And the purpose of that was to throw off what she did. It is impossible to believe that she did not have this idea ready to present when she made that call. Now, she stumbled over it. Saying STDs, and she meant to say PTSD, as she claimed in the statement. But all of that was false. Jake was not gay. Jake did not have STD. Jake did not have PTSD. She starts off with a lie. This was a premeditated lie. She had thought about it. And again, timing was everything. Jake could not find out what's going on with me. He could not go to that race and be presented with whatever he was going to be presented with and come back and kick me out or start the process to kick me out. So, that's what was going on. Premeditation, the thoughts of what she was going to do. And ladies and gentlemen, as the evidence shows you, she made certain errors. Well, let me go back a little bit. She made errors. She made errors in her plan. She's so smart. She's so smart, as she declares, you're not going to catch me. You're not going to catch me. I'm so smart. Now, these are the errors that she made. The first error that she made was the idea of claiming that Jake would want to kill himself. And that immediately was an error because everybody, doctor, says that Jake had no suicidal ideations and now he committed suicide. So that immediately blew her cover. Nobody believes that. Nobody believed that because there was no basis for them to believe or think that Jake would commit suicide. That was the first error. The second error, because she really didn't know her husband, she didn't know that he was a left-hander. And the most important shot that you're going to make in your life, if you're choosing to end your life, the most important shot that you're going to make in your life he was going to do it if he did it with his left hand. And he's undoubtedly left-handed, as you've seen. And consider that. It would have been just a natural thing. It's natural. You use your dominant hand. That was the second mistake. The next mistake that she made was again continuing the lies. She made an error in the notion that Jake would kill himself just before this most important day of him and Will's life. He had been working on that couple for years, planning on this race for weeks, meeting with his son that morning. And that was an error. Because it goes against the whole notion that he would commit suicide on this most important day. He would hurt himself just before the most important day he has with his own interest, and particularly with his son's interest and with his life. That was an error. Her timing was an error to kill Jake then. Where she was pushed by the fact that her being outed was going to happen at that racetrack. She knew that was coming. I got to stop this. I can't let Jake put me in a position where I'm being put out. That was an error. That was an error. I'm still getting ahead of myself. Let me go back a little bit to some important thoughts. I want to talk about all the lies that she told. If I'm back at that slide, I'm sorry, ladies and gentlemen. I'm a low vision person. Sometimes I'm missing some things, but I think you've followed my slides as I've gone along. And I want to go back to the lies that she told. First lie she tells is on the 911 call. On the 911 call, she lies about, I didn't touch anything. That's the first lie. Next lie is at the crime scene. She lies. We were having coffee when the shot rang out. That's what she's telling. That's what she's telling the police in the presence of the coroner. And you heard how that went, and how that was. And that in effect, that actually made a general plan work. The general plan to make it look like a suicide or to throw the police and the investigators off worked. So that was the next lie. The next big lie. And continuing lies. Now the next big lie, which she told in her later statement, is that the dog jumped on the bed. And that's why I got blood on my hand. The dog jumped on the bed. Now this dog, a Chihuahua, she claims that the shot went off, she ran, tripped, and the dog ran past her. It's that the dog's supposed to know where to go. The dog knew to go somewhere. How did the dog know supposedly to go somewhere? And jump up on that high bed that you see in the evidence. And then she jumps on the bed to get the dog. That's all a lie. That's all a lie. These are lies that Susan Embert has told throughout the process. Not to mention going back to the fundamental lie that she's saying Jake was gay. And all the lies surrounding that. The purposeful lie that she's telling law enforcement at the scene. She tells Officer Rogers Jake killed himself because he did not want his family to find out that he was gay. perhaps the officer maybe didn't process it immediately. He might have should have asked, now, Miss Embert, what kind of sense does that make for Jake to kill himself to keep his family from finding out when you know, supposedly, that he's gay? Maybe he didn't process that question in his mind at that moment. But you all have, you all see the question. The thing would have been if Jake was killing himself because he didn't want his family to find out, kill her. He should have killed her if he didn't want the secret to get out. Killing himself would not stop the secret from getting out if he's supposedly gay. But that was her story. Jake killed himself because he was gay and he didn't want the world to find out. Which is a lie. So, ladies and gentlemen, as you're processing this evidence, no matter what the defense says, whatever they say, these lies stand in the way. The lies that she told stand in the way. You cannot give credit for anything based on all these lies, these profound lies that you see. No matter what they say. No matter what they say about the investigation. No matter what they say about the court. No matter what they say about medicine. No matter what they say, these lies stand in the way of her not being guilty. And she is guilty. The lies are overwhelming. And the lies should compel you to find her guilty immediately. And you should. Now I think I want to get to the point where I was saying there are some issues without doubt. The issues without doubt, to begin with, number one, is that she is the first person to make contact with that body. All of this rigmarole about EMTs and people moving stuff, it is without a doubt, she is the first person to contact the body. That's indisputable. She admits that. So you don't have any doubt about that. First contact with the body is her, without a doubt. So that's not an issue for you to worry about when you're contemplating this evidence. Nothing they can say can change that point. She's the first person, well, EMTs could have done it. Or, no. She is the first one she admits it. There's no doubt about that. She has blood on her hands. No doubt about that. Will saw it first. Will saw it at the scene. Will saw it, and her story, the part of the lie about the dog, cannot be rebutted or refuted because Will saw the blood. So you have no doubt about that. She got blood on her hands. She has Jake's blood on her hands. No doubt about that. No doubt about that. No matter what they say, there's no doubt about that. And how do you get blood on your hands? Manipulating that body. Your common sense tells you that. Your common experience, common observation. You get blood on your hand when you're around blood, messing with something that's got blood on it. The blood is on the body. No doubt about that. No doubt about that. There's no doubt about this gun. You've had it. And you're going to have it back there. And you've gone over the fact that this gun will not fire. This Glock will not operate unless this safety mechanism right here in this trigger that you've all examined, that you've been shown over and over again, you're going to have back there again. Unless that safety is compressed, this gun will not fire. This gun will not shoot. It will not operate. It won't function. There's no doubt about that. And why is that significant? Because a finger has to be put on this trigger to pull it, to make it shoot. And it was her finger on that trigger that made it shoot. It was her finger that made it shoot. No matter what they say. Those three things are without doubt. You'll have the photograph. Jake's finger was not on the trigger. That hand, Jake's hand, was placed over that gun. You don't have to be a forensic evidence to see that. I mean, you don't have to be a forensic expert to see that. God almighty, that she messed up. Not only did she put it in the wrong hand, she didn't put the finger on the trigger. In her haste, fixing up the scene, she had 40 minutes to do it. She says that Will was never there. She says Will was never there. Again, another lie. Will has coffee with Jake. And she co-opts what Will and his father did. She takes over. It was all we were having coffee. She co-opts the situation in her lie at the scene. She does those things. So, ladies and gentlemen, the evidence in this case is overwhelming. And although this trial has been going on for perhaps now going on not whole 2 weeks, you should not be reticent in quickly finding this defendant guilty of all the charges. Quickly finding her guilty, holding her accountable for the murder that she did. Like I'm saying, the defense has no burden of proof. But I can tell you again there's things that the state has shown you beyond a reasonable doubt. And those things I just mentioned are things beyond a reasonable doubt. And these things, and you're looking at the indictment, which shows you what the charge is. The charge is that she manipulated the scene. She manipulated the scene. That is what you're looking at, comparing the facts in this case to what the facts are in the indictment, or the elements in the indictment. We're going to go over that again with you as the state presents the rest of this case. We'll go back over that. But there's nothing they can say. Any of this stuff about, poor investigation, experts who can't look at photographs and can't make up their minds. Experts who can't eliminate the fact that she did it anything they're talking about, Jake being on medicines that could potentially cause suicide. These medicines of people, if everybody that had a medicine that could potentially cause suicide just committed suicide, like I said, there's probably somebody in this courthouse right now taking medicines. You choose to commit suicide, you choose to end your life. Jake Embert did not choose to take his life. He did not choose to take his life on a most monumental day for him. A most monumental day for him and the son he loves. He didn't choose to take his life on that day. Jake would not do that to his son. Jake would not do that to his son. Like that. Within minutes after talking to him about going to the race. And see, that's the thing. She didn't know Jake Embert well enough to understand that. How important the race was to him. She, in addition to not knowing that, of course, she didn't know what hand he used. She did not really know Jake Embert other than he's a meal ticket for her. He's a house for her. He's support for her. She's spending her money and his money. And I can't let that in. And I get a big payday if I can wait him out. He's gonna die. That's what she's espousing. If I can wait him out, but I can't let him divorce me, I can't let him kick me out, I can't let this situation get out of hand. He's more valuable dead. He's more valuable dead to me, Susan Embert. More valuable dead. I can't let him get in a posture where he's going to be kicking me out. Can't let him do it. That pushed her timetable up. So ladies and gentlemen, I'm going to tell you once again, before I sit down, that the evidence is overwhelming. Susan Embert is guilty. You should cling to the things in which there is no doubt. These things spell out the fundamental elements of this crime. And that's what you're looking at. You're not having to look at speculation. You have to look at conjecture for these things. She's the first one to have contact with the body. She's got contact with the body. She's got blood on her hands. She admits that. It's documented by the evidence. There's enough information for anybody to see that this crime scene was staged. You don't have to be an expert to see that. You see it right now in the evidence that you've seen. You've heard the lies, the obvious lies. You cannot put any faith in any argument relating to anything that makes her credible. She's consistently lied, notoriously lied. She's so smart. She lied about what she does for a living. She lies about everything. And you, ladies and gentlemen, should hold her responsible Because her lies, her decision, her avarice, she says she loved Jake Embert to death. Well, she loved him to death, all right. That's what she did. She loved him to death. She loved him to death because he was more valuable to her dead. All of the elements of this crime will be met in the second part of what the state will present to you in this case. You will see this. Again, return a verdict that speaks the truth. Defense will make arguments that are useless, they're meaningless, they have no value. They really don't. The arguments they have no value. No value at all to the truth. So, return a verdict that speaks the truth. The truth is that defendant sitting right there and don't succumb to any courtroom theatrics. This defendant is guilty, and we ask that you return that verdict so that justice can be served. So justice can be served for Jake Embert, whose life he did not choose to end. She chose to end his life. Find her guilty. Your Honor, that completes the state's opening argument.
Good morning. It's been a long couple of weeks, hasn't it? And I've been wanting to talk to you for the entire time, the entire trial really, but especially since the state rested. I have never been a part of a murder case where the state was so unsure of their evidence that they rested their case and got through the first half of their closing argument without ever telling the jury the facts of how the murder is supposed to be committed. I want you to take a moment and think of any question you have about how this murder was allegedly committed. Any question at all, just hold it in your mind. You might be wondering what the state's theory of how this murder was committed actually is. That's a good one, because they haven't given us any specifics. They haven't put up a single witness to tell you this is how it happened. If she's supposed to have shot him, you might be wondering, can she shoot a gun? If she can shoot a gun, is she a good shot? We know that this is a head shot, okay, a head wound. You may be wondering, is there space in the room for her to have shot him in the way I suppose she would have had to without causing stippling? You guys remember you learned about stippling. If you're close to someone, you're going to see all those red pot marks. You might be wondering, does the trajectory work? Does the trajectory of the bullet through his head and into the wall, where they dug it out of the wall, does that work with her? Is there a place in the room for her to stand where that trajectory makes sense? Or does the room itself, do the dimensions of the room make that impossible. And I'll tell you right now, you're just going to have to excuse my handwriting, because it's not great. We can see that. You might be wondering, what about her height and his height on the bed? If he's sitting on the bed and she's standing over there, and again, this is me hypothetically saying she's standing over here because they didn't have a witness tell us. No witness has gotten up here and said she'd stand over here, shoot him in the head, any of that. What about their heights? Does that work? Does that work with the bullet angle? Or does that show that she can't have shot him from over there? You've heard about contact gunshot wounds. You've heard some evidence that this might have been a contact gunshot wound. How on earth is she supposed to have walked up to him and put a gun to the side of his head and pulled the trigger, and there's no sign of struggle whatsoever? How does that work? Does it work with her standing up? Or would she have to sit down next to him on the bed and hold her arm across like this? How does that work? How does any of that work? Some of you thought of questions that I haven't even talked about, that I haven't even addressed. All of these questions are reasonable doubts. All of these questions are reason there cannot be a conviction in this case. And whatever question you have in your mind, whatever thing you thought of, I can tell you with 100% certainty, the state did not address it, they did not overcome it, they did not rule it out. Why can I say that? Why can I say that with certainty? Because they never put up a single witness to tell you how this would have happened. Now they're going to come after me and they're going to say they're proving this case with circumstantial evidence. Okay? That's what all the Susan said this and Susan said that and Susan didn't pay the utility bill and whatever, all that. That's supposed to be circumstantial evidence. But if the state is proving this case with circumstantial evidence, that evidence has to be so strong that it rules out any reasonable hypothesis except for one, the hypothesis of guilt. You don't even have to believe other hypotheses. They just have to exist and be reasonable. So if you're talking in deliberation and you say, someone says, well, I think, what about this? This is a reasonable hypothesis. And you say, yeah, I don't believe that, but it's reasonable. That's it. That is a not guilty. There is no conviction. Now, what do we know about the circumstantial evidence that actually relates to murder, not just the, Susan had house rules, Susan's a bad person? It shows that she was there. And that's about it for the circumstantial evidence as to murder. And as the judge is going to instruct you, being there is not enough. We call that mere presence. There's actually a specific instruction for it. Mere presence, where someone, if you are at a scene where something happens, that does not mean, that is not enough to say you are guilty of anything. Okay? So showing she's there is not enough. I mean, what were they doing? What were they doing with this case? We've been here for 2 weeks. We've heard from 3 experts from the state side. We've heard from family members. We've heard from coworkers. We've heard from doctors. we've heard from all these witnesses, and no one has given you what you need to prove murder. I mean, they just got so wrapped up in trying to rule out suicide and trying to do this, step one, that they never moved on to step two. They never gave the evidence needed to prove murder. What would it have looked like if they had done it? What would a real murder trial look like, where they are actually giving you evidence to prove a murder, to prove how this murder took place, to deal with all your reasonable doubts? Well, like anything, it would come from the witness stand. You would have a witness talk about it. And that witness can talk about all of these things we wrote down here. They can address, yes, she was standing here, and we think she, based on where we recovered the shell casing, that she shot like this, and the trajectory works, and their heights match up, and there's no problem with the wall, and there's no problem with the space in the room. It checks out. But they didn't do that. They got experts who spent all their time talking about bed sheets and blood spatter, and nobody who told you how the murder happened. I have never been a part of or seen a case where the state does not address the murder part of a murder charge. It's unheard of. It's unheard of because you can't have your reasonable doubts about the murder satisfied if they don't tell you anything about the murder, if they don't offer you any evidence about the murder. How can you convict a woman of murder if you don't know how she's even supposed to have done it? And that brings up another problem. The absence itself is doubt. The absence itself is doubt. Do you think that if they had all these things, or any of these things, excuse me, do you think if they had any of these things that showed murder, that explained what's going on here, they would have just kept that to themselves? They would have kept it a secret, not told you about it, not bothered putting up a witness? No. What does that tell you about this? What does that tell you about the theory? It's not provable with evidence. They can't do it. They didn't put anybody up because they can't get anyone to say, yes, this is a murder. This is how it happened. Now, when I got up here the first time, I wrote down rule out suicide because I knew the evidence couldn't do that. But never in my wildest dreams did I think they would stop there at trying and failing to rule out suicide and not even go on to prove the murder. I mean, let's be clear. We heard a closing argument yesterday from the state. A closing argument, and they didn't tell you how she's supposed to have done this, what she's supposed to have done. Imagine that. They still haven't told you. How does the conversation go if you're trying to explain this murder to someone else? We convicted her of a murder. Okay, well, what was the evidence? Well, he died of a gunshot wound and she was there. Okay, well, she shot him. Did she shoot him from close up or far away? I don't know. Really didn't get into that. Okay, well, did the trajectory work? We didn't talk about the trajectory. Okay, was there space in the room for her to do this? I don't know. Now, just to be clear, they did not rule out suicide. They did not rule out suicide. You heard Will Embert testify that his dad liked to shoot his right-handed gun with his left hand. Okay, you can take that or leave it. The only way it rules out suicide is if you heard that he can't shoot with his right hand, that he can't do it. And they keep saying things like, this was the most important shot Jake Embert was going to take, which I think is a very strange way to talk about suicide. But I think we can all agree it's not a hard shot to make. It's not a hard shot. You can shoot yourself in the head with either hand. And basically, their whole "the suicide looks weird" thing collapsed when we talked about the EMTs, because it was based on the idea that nobody could have touched the body with Susan and before Susan, and nobody touched the body before the pictures were taken. And if someone had, that meant Susan murdered him, was trying to stage a crime scene or something like that. But why not call the EMTs? Did you hear from any EMTs? If that's so important, if the movement on the bed is so important, do we want to hear from the EMTs who may have checked for a pulse, who may have tried to see whether he was dead, who may have moved the body just like they're saying, just like Brian Smith was talking about? Every single one of those EMTs that they didn't call is walking reasonable doubt. They could have called him. They didn't. So, speaking of the EMTs, let's talk about James Adams, the first officer on the scene. We learned through James Adams that EMTs were there when he got there. We learned through James Adams that, and I'm just going to move this a little bit, that an EMT gave him the shell casing, in fact, and we know that when he was taking this picture at 11:21, what were the EMTs doing? The EMTs were requesting the coroner. They'd done everything they could do. They determined he was deceased, and they needed to have the coroner come out. So by the time James Adams is taking this photograph, the EMTs have already done everything they're going to do at the scene. Okay? But let's ask the big question. Did James Adams, did any of these witnesses, I'm going to try to ask it with every single witness, did any of these witnesses tell us anything about how the murder's supposed to happen? No. Did they tell us anything that would rule out suicide as a possibility? No. Did he tell us that he believed it was a suicide? Yes. Like every single other professional who arrived on that scene, who looked at that scene with their own eyeballs, he thought this was a suicide. He told us nothing about murder. Then we had Officer Rogers. Remember Officer Rogers? Did Officer Rogers tell us anything that could rule out suicide? No. Did he tell us anything that could explain the murder or give you an idea of how it was committed? No. We heard from Coroner Fowler. Now, when you have a witness who you think is going to give you testimony that's going to be contradicted by the evidence, it's a good idea to just lock that witness into that testimony and then bring the evidence, confront them with the evidence. So that's what we did with Mr. Fowler. We locked him into the statement that he changed the death certificate on or by August 26, 2014, and then confronted him with the fact that Lee Wilson was still talking to him and calling him and writing him letters and all this stuff, trying to get this changed from a suicide to a murder after he said he'd already done it. And you remember what his explanation was. The best he could come up with was that maybe Lee Wilson just didn't know that he'd already changed the death certificate back in August. And that's why they were still talking about, we got to get this changed. We got to get this changed from a suicide to a murder. You get to judge the credibility of the witnesses. So I'll leave the credibility of Coroner Fowler on this issue up to you. But whatever you think about his credibility, did he tell us anything that would make this a murder? No, he did not. Did he tell us anything to rule out suicide? No. In fact, he told us that he ruled this a suicide, a contact gunshot wound to the head that was self-inflicted. There's nothing making him do that, okay? And I want to talk a little bit about that because the state's theory seems to be now that Susan lied to Coroner Fowler and tricked him into saying it was a contact gunshot wound and it was a suicide, and then once he found out that she was lying, he changed it. That's mostly from the closing argument of the state, because it's not supported at all by the witnesses. What did we actually hear? What did Coroner Fowler actually testify to? He said he overheard a conversation between Miss Embert and a law enforcement officer where Will Embert is standing right next to Susan, okay? He's taking his notes, and he's overhearing this conversation, and she used the word we. And he mistakenly thought that the word we meant her and Will were in the house, okay? It's not some Susan tricked the coroner. No, the coroner made a mistake, if he's telling the truth about that conversation, made a mistake about Susan Embert and the word we, who that encompasses. And even then, even if you believe this, that he accidentally wrote suicide because he overheard this conversation, which is hard to fathom, that that's what determines the cause of death. Even if you believe that, that doesn't trick him into writing contact gunshot wound, okay? These people are trained. You're trained. You write contact gunshot wound only if there's evidence of a contact gunshot wound. And we learned that's a very specific thing, right? So he can write gunshot wound to the head, anything like that. Contact gunshot wound came from his own observations at the scene, from him looking at the wound, feeling the wound, doing the things that he did, that he's trained to do. That's why the word contact is on there, okay? That doesn't get explained away no matter what Susan Embert says. Even if Susan had had a conversation with him where she lied to him, that doesn't change contact gunshot wound. So now you've got to believe, I guess, that she's standing or sitting right next to him with a gun pressed up against his head. And just to go back to Will for a little bit, we heard that he thought he saw blood on Susan Embert's hand. The problem with that is he didn't tell anybody at the scene. He didn't tell anybody. The scene is swarming with police officers. He's right there next to Susan while she's giving a statement. Doesn't tell a single person at the scene. Not a soul. The police officers who were there, you think if they're responding to a gunshot, a homicide, suicide, whatever, I mean, they go in treating everything like it's the worst possible thing. You think they might look at people's hands? You think they might check to see if there's blood on them? Nobody at the scene, no police say there's blood on Susan Embert's hand. I think they look for that. It's also, we don't know what he saw on her hand. We also know that if she tried to get the dog off the bed or any of that stuff, that's a way to get blood on your hand. So none of this stuff works to rule out suicide or prove a murder. We heard from Steve Shimon, the firearm tool expert who got the gun, said in a lot of suicides he gets, the gun's got more blood or debris on it. But he also said he thought he saw biological material in the barrel of the gun. You learned that he tested the gun for blood, and it was positive. He talked about aerosolized blood, exactly the kind of blood you would get with a contact gunshot wound. Okay? Now, if there's aerosolized blood on that gun, we learned from, I think, just about all the experts, it's very hard to see, but also, how on earth do you get the aerosolized blood on the gun and in the gun, inside the gun, on those bullets that you heard about? How does the blood get on them if it's not a contact gunshot wound? Okay? If their theory is Susan shot him from over here, he's here, how does the blood get sucked into that gun? How does it travel way faster than it could possibly travel to get inside the gun? It can't. So the only explanation you're left with is that the theory now has to be standing or sitting, if the angles work. I don't know, you don't know, because they never put up a single witness to tell us, contacting his head. And he doesn't move, and he doesn't struggle, and he doesn't turn away. You heard from Brian Smith, Agent Brian Smith. I really admire Agent Brian Smith, even though he doesn't like me using the term right-handed gun, because you saw how hard they tried to push Agent Smith to go further than the facts would let him, to go further than he was comfortable with his testimony. You remember he just kept saying, stuck to his guns. If absent some other blood-bearing surface in the room, there's a little void. I think that the body may have been moved a little bit. Can't say why, can't say who did it, can't say what it means, can't say if it's indicative of suicide, can't say if it's murder, can't say anything. I mean, his refrain was, can't rule it out, can't rule it out, can't rule it out. Can't rule it out is a not guilty verdict. If there are things that you can't rule out, that is not guilty. The state has to rule them out for you using evidence from this witness stand. And that time has passed. Whatever they come up with after me to explain this all away, understand that I am talking about the absence of evidence. There is nothing they can do to cure that at this point. We heard from Dr. Houston, And you remember how shocked the state was when they actually heard the testimony of their own witness. You heard from Dr. Houston, you heard Devin ask Dr. Houston, what would you have done if Jake Embert came to you and expressed a suicidal ideation? What would have happened if Jake came in and said, I think I'm in trouble. I think I'm suicidal. He would have been put on an antidepressant and referred to a psychiatrist. What did we learn happened? He was put on an antidepressant and he was referred to a psychiatrist. We also learned that he was taken off the antipsychotic that he was taking right after his second heart attack and right before he committed suicide. That is as clear a line as you can get in terms of medical causation. Has a second heart attack, taken off his antipsychotic, commits suicide. You also heard from Rachel Embert. You heard and you saw how badly she needs this to be a murder and not a suicide. How badly she needs to believe her father could not take his own life. That is completely understandable. Completely. You heard her tell you when she got to the scene, she had her fists balled up, she ran up to Susan, and she said, what the fuck happened? What the fuck happened? There is nothing, no evidence, nothing anyone could say that is going to make her believe her father was capable of taking his own life. Nothing at all. You heard from Yvonne Magnus. You heard that Yvonne hired Lee Wilson, and you remember Lee Wilson. Rachel and Yvonne have spent the last 12 years with Lee Wilson trying to get this turned from a suicide into a murder. The problem is, when you're taking 12 years to do that, sometimes your statements change. You saw how often Ms. Hyman had to come up here and confront the witness with a previous sworn statement. We heard from Douglas Buckner. We learned through him that Jake had a hard time trading the car. Trading the car was hard on Jake, of course it was. And also, just to do with Douglas Buckner, this whole idea that just popped up in the state's closing argument about Douglas Buckner was going to tell Jake something on Saturday, so Susan had to kill Jake, that moved up her timeline. We know from the testimony, you know from the testimony, that's false. You know from the testimony that him and Jake were talking and texting and had a regular flow of communication. We know, in fact, that he even revealed the big secret that Susan had texted him, the thing that was supposed to make, Jake was going to divorce her or something like that. He told him about that on Friday. She didn't have to kill him to keep him from going to the racetrack. There's nothing to support that. And also, the idea that they're getting divorced is this new thing that's invented by the state, that there's no evidence to show at all. The one thing you have is a question from Will, a teenager, who, for him, I don't know if your ideas about marriage and love have changed since you've been a teenager, but for him, any fight, it's a reason to break up. So he asks his dad, are you and Susan going to break up? No. There's no evidence that they were getting a divorce. There's no evidence that he wanted to divorce her. There's none of that. It's just pure speculation, and it's meant to distract you from this, from all of the real questions, the evidence questions that you have about this murder. Let's go back to Jake and this car. because the state keeps talking about it like he never would have killed himself given what was going on with the car. And I don't know if they just haven't thought about this or they don't want to talk about it, but isn't it possible that trading away this race car that he's worked on for 17 years, trading that away, watching someone else own it, watching someone else drive it, watching someone else get it running, that maybe that wasn't a happy thing for Jake Embert? That maybe that was, in fact, one of the things that led him to end his life on that day? He did not want to go to the racetrack and see that car that he no longer owned being driven by somebody else down that track. I mean, when we're talking about suicidal people, I hope we all agree that when you're suicidal, you're not making rational decisions. I hope we agree on that. Mr. Edwards talked about kamikaze pilots in World War II yesterday. That's not what we're talking about here. We're talking about someone who is deeply depressed, someone who has anxiety, someone who has panic attacks that look so bad they look like seizures, someone who's had 2 heart attacks, someone who's losing their autonomy, someone whose world is closing in. That is the state that Jake Embert was in when he took his own life. And the state is also saying, oh, well, he wouldn't take his own life if he had plans that day, if he'd made plans to do something. People who are suicidal are not behaving rationally. If you are deciding to take your own life, you are canceling all your plans. You are deciding not to live anymore. The fact that you have something that is happening that afternoon is not going to stop you from taking your own life once you've decided to do it. Now, we heard from Bruce Willis, the guy who teaches the experts, and we heard all of the reasons that this scene does not support anything that the state is trying to get it to support, that you can't make any of the conclusions they're trying to get you to draw. You can basically say, there's a body, it could have been moved, might not have been moved, suicide, homicide, I don't know, right? Now, Bruce is a guy who testifies for the state. He testifies for this DA's office. When the evidence is there, he's the first guy on the stand to put the bad people in prison. You remember how shocked the state was when they learned how much he'd been paid? $800. They had to ask the question twice. Only $800? You did all this work for only $800? I mean, is that how it works? Is that how it works? Is there nothing that is more important than money? Is it possible that there's something more important to people like Bruce Willis or even Brian Smith, that they won't go beyond what the evidence shows? Is it possible that one of those things is making sure that the people who don't have anything, the Susan Emberts, don't get run over every single time by the people who can afford to hire a private investigator for 12 years? That could be more important than money. It could be more important than money to keep an innocent woman out of prison. That could be more important than money. I mean, how does it work? Who gets justice? Who gets justice? Is it just the people who can afford to put a private investigator at counsel table? Have him sit at counsel table throughout the entire trial? Have him work for 12 years? Or is it the people who can't do that? Do they get justice too? Luckily, They don't get to answer that question. You do. You get to answer that question. We heard from Lee Wilson. Lee Wilson did his best to try to give Coroner Fowler an out on the whole statement that he changed the death certificate on August 26, 2014. And by an out, I mean a reason for that. When he's giving the testimony and everyone outside of this jury box knows that what he's telling me isn't true. Now, Lee Wilson didn't jump up and stop the testimony and tell his lawyer, the lawyers to correct it or anything like that, because he said, it's just a mistake. It's just a mistake. Just a clerical error. Okay. That's one theory. Another theory is that Coroner Fowler knew exactly how suspicious that would look. He knew exactly how suspicious, how bad it would look if he only changed the death certificate right after months of meeting with Lee Wilson to get this changed from a suicide to a murder. He understood exactly how bad that would look. And this is why, again, our criminal investigators, our police, yours and mine, they don't work for private individuals. They work for the state. Because when you start an investigation with a set goal in mind, you're going to try to get somebody convicted of something, you're not following the evidence. You're just trying to find things to support your theory. You're finding things to support your goal, especially if you have a financial incentive to do so. That's the problem. But what happens when you do that, when you have a case like that, is you end up with this. You end up with a whole bunch of stuff that makes one person look bad, but doesn't do anything to tell you about this, to prove murder. That's the kind of case you end up with. That's why we don't investigate crimes like that. Now, let's talk a little bit about something the state likes to talk about a lot, which is the 911 phone call. And on the 911 phone call, Susan Embert says, Jake Embert is gay. It doesn't make a lot of sense. It doesn't make a lot of sense. And I don't know how much experience you have with trauma or anything like that, but I think we can agree that people in those situations don't always make a lot of sense, especially if they are dealing with something like finding their spouse who has just taken their own life. All the anxieties, all the things that you heard about in her testimony, the problems with their sex life, low T that you learned about from Dr. Houston, all those anxieties come out in whatever she's saying. She's finding a reason that this happened. I think you can even hear her on the call say something to the effect of, how could you do this? How could you do this to me? She's trying to find a reason. Now, I want you to listen to her voice on that call. I want you to listen to the sound she is making. I want you to listen to the grief and the sadness and the inability to process what is going on. And I want you to ask yourself, really ask, if you think that my client is that good of an actor, if you think that the person who is mixing up PTSD and STDs is that good of an actor, is that kind of a Hannibal Lecter, ice-cold killer who is capable of executing her husband at point-blank range and then meticulously, but impossibly quickly, arranging a crime scene that is so well staged it fools everyone, and then making that phone call. Does that seem reasonable? And even if you think she's capable of that, even if you think she's capable, they still have to prove that she actually did it. Which witness did that? Which witness told you about that? Not a single one. They haven't told you how this is physically possible. And even though they haven't given you a theory of the case, and we could literally just sit there and not say anything, and this would be not guilty, because they haven't given you a theory. But I think we need to deal with some of the problems that are obvious from the evidence that's been admitted. So I'm going to ask my colleague, Jennifer Hyman, to come up here for a moment. I'm just going to put, and again, this is a picture that contains material that may prove disturbing if people want to adjust accordingly. So, we know, or I think we know, I don't know because the state hasn't really talked about it at all, that he would have had to have been facing forward because he's shot on this side of the head, right? So, Jen, we're just going to do the measuring tape. And when we get to 12 feet, we've heard from their expert that we at 12 feet, their expert, that you can get stippling at 12 feet. At 12 feet, she's outside that room. She's outside the room at 12 feet. Where's the 12 feet for her to stand? Here. Here. Where is it? She perched on the dresser? Where is it? Okay, so maybe it's not 12 feet, and it's closer, and it's closer. But then you're getting stippling. And we would have seen all those red stippling marks, like the one Bruce Willis showed you. Okay? So now, their theory has to be, it's a contact wound. She's standing right there, or sitting. I don't know if the angle works, if she's standing. But it's a contact wound. And once she shoots, all she has to do is put the gun down to stage the scene. That's all she has to do. And we've seen his hand in that picture. They made a big deal about there's no blood on his hand. Now, we of course heard that there's aerosolized blood on the hand, and a lot of times you don't see blood and all that. There's no blood on the hand. That means it had to be staged. Okay, well then why is the fact that she's got blood on her hand, how is that evidence of staging? If all she had to do was just plop the gun right there. It doesn't make any sense. All of these things, all of these questions were questions that had to be dealt with by witnesses from that stand. Now, I know the government has not proved its case, but what they're really going to do next is what starts to concern you, because they're going to ask you to make up for that fact. They're going to ask you to fill in the holes. In spite of giving you no evidence, they're going to ask you to convict this woman, Susan Embert, of murder. They're going to say it's your responsibility, or it's your duty, or whatever. This is the moment that the jury box was invented for. This is the moment the founders saw 250 years ago. The founders weren't perfect, but boy, were they familiar with a government who throws people in jail without evidence. That's why they put this protection in place. That's why they made sure that the only people who could do that were a jury of someone's peers. A jury of someone's peers was the only group they could trust to make the government rule out every reasonable doubt, to require the government to prove every element of every part of its case beyond a reasonable doubt. Not a group of prosecutors, not a group of judges, not a group of nobles. A group of people from that person's community could be trusted to protect that person. I want you to ask how she's supposed to have committed this murder. And if you can't answer that definitively, if you can't say that, if you can't explain it to each other, find Susan Embert not guilty. When you go back to deliberate, ask, did they rule out suicide? And if someone says yes, ask them, what's the thing that made suicide impossible as a reasonable possibility? Not whether you believe it or not. What's the thing that made it impossible to be a reasonable possibility? There's many things we know about Jake that contributed, that made it reasonable. It's never reasonable. That made it understandable for him to commit suicide. All of the medications he was taking, being taken off the antipsychotic, having medications increased, the health problems, the heart attacks, the financial problems, the loss of autonomy, the loss of his prized possession. All of these things make it reasonable. Ask, did they prove murder? Explain the murder to each other. Because they want you to just plug or ignore these holes in their case. But you have sworn an oath not to do that. You have sworn an oath on your honor not to do that, to take only evidence, to judge only on evidence from here, to see whether the state has proved every element. And I was talking to a good friend about wrongful convictions, and he said something that stuck with me, and I want to read it so I know I'm getting it right. He said, you know, at some point, every jury in those cases talked themselves into accepting what the state was telling them instead of questioning it. At some point, every jury in those cases talked themselves into accepting what the state was telling them instead of questioning it. And it stuck with me. It stuck with me because you've seen these wrongful conviction cases. And you've seen the state doesn't take responsibility. What do they say? They always say, oh, we gave it to the jury. We put it in the jury's hands and let the jury decide. Clean hands. Clean hands. I wonder how those juries feel about that. The state will sleep fine no matter what happens in this case. In a minute, they're going to act like it will be the end of the world if you do not convict this person. But as soon as this is over, it ends for them. They go right on to the next thing. let them sacrifice your oath, your honor for this. It's too important. It's too important. Do what you're sworn to do. Look at the evidence, at the lack of evidence, and tell them no. Say, you had 12 years to prepare a case. You had 12 years to bring this. And you did not bring us evidence to prove murder. You did not bring us the evidence that the law requires you to bring us. If you wanted a conviction, you needed to bring us the witnesses. You needed to bring us the proof. Not the innuendo, not the rhetorical flourishes. You needed to bring us the evidence. Do not let them make you their accomplices in this 12-year destruction of Susan Embert's life. Do not let them do that. Tell them no. You are the most powerful people. When you are in that box, you are the most powerful people in our legal system. You are the guardians of the law. Use that power. Use that power in the deliberation room. Tell the state no. We will not sacrifice our oath. We will not go back on our oath. We will not sacrifice our word, our honor. Give this woman her life back. After 12 years, give this woman her life back. Find Susan not guilty. Thank you for your service.
All right, we've got everyone ready to proceed?
Yes, Your Honor. May it please the court?
Yes, sir.
Hey, y'all. I know, like the defense said, it's been a long 2 weeks. I appreciate your service, and I appreciate your time. I know both parties appreciate you being here. I want to start with something that I thought was pretty interesting in the defense. They refer to us as the government, right? The government, the state. Here in Doherty County, we're a government by the people, for the people, to serve the people, and to protect the people in this community. That's me, that's Mr. Edwards, that's Lee Wilson, that's Guy Terry, that's Rachel Embert, that's Will Embert, that's Yvonne Magnus. Ladies and gentlemen, there may be two sides to every story, but there's only ever one truth. There's only ever one truth. The weight given to any piece of evidence that you've gotten during this trial, whether it's direct, through testimony, physical evidence, the gun, the bullet, the circumstances surrounding what happened, the weight given to that evidence, it's not up to me. It's not up to the defense. The weight given to that is up to you. It's always up to you. Hope everybody's okay. So we talked about direct evidence. That's stuff that directly proves something. For example, you have a witness testify, I saw Mr. Jones shoot Mr. Smith. You see that, right? That's something that's direct. You see it directly. Then there's circumstantial evidence, which I was interested in the defense's theory about circumstantial evidence because they want you to believe that it doesn't matter. That you can't prove a case on circumstantial evidence. Circumstantial evidence is your interpretation of everything that you've heard. As Mr. Edwards, I love listening to Mr. Edwards when he gives his closing statements, opening statements, because he has so much gravitas and he's so experienced in what he says that it's our job, it's your job to accept what's reasonable and to reject what's unreasonable. The really interesting thing about being a juror is that you have to consider all of the evidence that you've heard, all of the evidence that you've seen, and all of the evidence that you've felt in light of your reason, your experience, and most importantly, and I think we lack this as a general public, common sense. It's not hard. There is no reason to be skeptical of evidence, only because it's circumstantial. Because you know what you see, you know what you hear, you know what you feel, you know what you trust. You know that. I can't know it for you, you know that. We make decisions based on circumstantial evidence every single day. There's no reason why we can't use circumstantial evidence in the courtroom. As far as its value, like I said, the weight given, it's up to you. There's no legal distinction between it, between direct evidence and circumstantial evidence, because you give it the weight. That's up to you. It's not up to the defense. It's not up to me. The law allows you to give equal weight to both. And it's your decision to make. I want to give you an example of circumstantial evidence. I said we use it every day. So if you assume that it's a night in December, weather's clear, you see the stars, you see the moon, you getting ready for bed, you don't see any snow on the ground. You go to sleep. You wake up the next morning, there's snow on the ground, and you see footprints across your grass. The direct evidence, you see the footprints, you see the snow. You didn't see snow before you went to sleep. You saw it the next morning, and you saw footprints in the snow. Your common knowledge, your common experience, your common observation, and your common sense leads you to conclude somebody walked across your yard after it snowed. We can employ that same logic, that same evaluation on the defendant's actions in this case. Mr. Edwards had a chart. I love this chart because it demonstrates exactly how juries make decisions. You take your physical evidence, you take the testimony, you take the documentary evidence, like the CAD sheet, that shows you EMTs didn't get to that house before James Adams did. You saw that. And you look at that with your common sense. Again, it is your job to accept the reasonable, to reject the unreasonable. Let me give you another hypothetical for circumstantial evidence. You hear a gunshot. You see a person run out of the room. That person has a gun in their hand. The gun's still smoking out of the barrel. The room doesn't have any windows. The room has one door. Inside the room, there's a dead body. And that dead body was a person who was shot in the back. Nobody else in the room. You're allowed to infer the person who ran out shot the victim. The victim committed suicide, or someone else did it. The person who ran out shot him. It's reasonable. The person committed suicide. Wholly unreasonable. Someone else did it. Nobody else in the room. Unreasonable. I'd like to warn the family. Sorry, I didn't realize it was coming up that quickly. Circumstantial evidence. You've heard discussions at length, and again, I apologize. And I was up front from the very beginning. This is a very heartbreaking case. It's devastating, and it's graphic. I don't like looking at it. I have to assume the general public doesn't like looking at graphic stuff like this. But it's critical because there were two people in the house when that gun was shot. One of them was Jake. The other one, Susan Embert. So your inference, as the defense just posed to you, that Susan killed him, that Jake shot himself, or that it was an accident. Accident, unreasonable. You heard Judge Shimon testify about the mechanics of that Glock. If you've ever shot a Glock before, you understand that it's not going to fire by accident. They do tests on Glocks where they run them over with cars. And that safety mechanism in the trigger doesn't fault. That he committed suicide. Unreasonable in this case. Gun was in his right hand. And I'll talk a little bit about this later. It was a .45 caliber handgun. That's not a small caliber. It's not a 9mm. It's got more gunpowder than that. That the only other person in the house pulled the trigger, reasonable. Again, I told you up front, I was never going to misrepresent anything to you. We told you that. Mr. Edwards told you that. Mr. Terry told you that. The law enforcement investigation and the coroner's investigation into Jake's death that day could have been better. I told you that from the very beginning. The defense loves to attack it. But we know that. You know that. Everyone who's watched this trial in this courtroom knows that it could have been better. But the coroner's not on trial here, despite how much the defense wants him to be. Doherty County Police aren't on trial here, no matter how much the defense wants them to be. And we talk about the pictures in this case. Like I said, some are very graphic. And you've heard the defense expert and the defense themselves say, we need more pictures. We have to have more. Ladies and gentlemen, a single picture is worth 1,000 words. That's colloquialism. You know that. Everybody knows that. But if you have 1,000 pictures that are the exact same, it's a picture of the exact same thing that you're looking at. If you have 1,000 pictures of the same thing, it's the same value as having one picture of the same thing. Luckily, in this case, Doherty County, we have a lot of great forensic help. And we have some crime scene analysis to help us here. Ladies and gentlemen, the evidence is clear, despite the defense's contention. This was not a suicide. And it's not that the state, the government, hasn't ruled it out. The evidence rules it out. So let's talk about what the evidence showed at the crime scene. The crime scene was staged. Looking at those pictures, that's the reasonable conclusion. And you heard Agent Smith, Sergeant Bilsby, who has led over 3,300 investigations with the Albany Police Department. Over 300 suicides. And he said that he uses pictures, he looks at pictures to analyze every single one. And that's exactly what he did in this case. Despite the fact that the photos were taken in 2014, he was able to look at those photos and do what he does every day. The defense pointed out that was a weird way to refer to it as the most important shot of Jake's life. But ladies and gentlemen, that's exactly what it is. when a person makes that decision, that's the most important shot they will ever take in their life. They're not firing at a metal target at the gun range. This is truly a life or death shot. Take a look at this photo and examine it as hard as you can. I want you to look at it. You've looked at it a lot. Jake's fingers aren't even close to the trigger, to the trigger guard. And let's keep in mind, this is his non-dominant hand. I can't hit anything with my left hand if I shoot a .45 caliber. And despite this left-handed, right-handed gun, which I think it's incredible that has become an issue, that doesn't exist. You've heard testimony that doesn't exist. This Glock was a Gen 3 Glock 30. It couldn't have been modified for a right-handed shooter left. It came one way. It came one way. Magazine release, slide lock are going to be accommodating a right-handed shooter because most people are right-handed. It comes one way. You heard testimony. Jake never shot a gun right-handed. He shot with his left hand. Every single time. And that's important because why would Jake make this decision to pull the trigger with his non-dominant hand? It doesn't make sense. Again, accept the reasonable, reject the unreasonable. The tape measure demonstration was pretty neat because I thought it was actually pretty effective to help us demonstrate exactly what we think happened. But that's a question for you to decide. That's what's critical. I think the phrase was accomplice in the state's charade or something to that effect. Ladies and gentlemen, was the gun in close contact? Was it not? That's your decision. The state can't bring you a witness who can testify to what happened. There were two people in that room. One of them is dead. That's the other one. Ladies and gentlemen, this scene was staged. You heard testimony at length about that. No blowback, no blood on Jake's hand. And I hate that this is something I had to ask, something I have to present. A dead person can't wash that off. No visible signs of blood on the gun. There were trace amounts. That's when you take a Q-tip, a cotton swab, and you swab the gun. And that's when it tests positive. The slide of the gun is under Jake's leg. If a person pulls the trigger, how does the gun get under him? .45 caliber is one of the most powerful calibers of pistols. It carries with it pretty significant kickback if you've ever fired one. Examine Jake's arms in this photo. Examine his hand, but look at his arms. Almost straight down to his sides. How does that happen? You heard from Sergeant Billsby, that doesn't happen. The wounds on Jake's head. We heard the defense expert yesterday talk about wounds in general. There's no stippling or tattooing at that wound. You can see that. No burning or singeings of Jake's hair. You can see that. Jake would have had to hold that gun with his non-dominant hand away from his head. But somehow his arm was by his side. Gun stayed in his hand. Pulling with his weak index finger. Is that reasonable? Or is it unreasonable? I want you to pay close attention. I want you to look at the bed sheet right here, right? That's called channeling. Like Sergeant Billsby explained, it's like if you imagine a stream of water running and you stick your hand in it, the water's going to go around. It's going to make that same pattern. Meaning, Jake wasn't moved around. He was pulled. He was pulled. These bloodstains, you heard testimony, that indicates he was dragged. And this blood pool here, does it look like it was from a chihuahua or a dog? Does it look like that to you? You heard Sergeant Billsby say that smear was a result of blood pooling. Blood sat there. If blood brushes across the surface and it doesn't have time to come out, I know this is graphic, I know this is gross, and I'll try to move on. You get that color. But if something sits there and bleeds, you get that one. This is the most telling photo. This void. Can you guys see that? You see there's a gap here. Something prevented that blood from pooling evenly or even dragging evenly. You heard Sergeant Billsby say the sheet was probably pinched. How would the sheet get pinched and unpinched? Jake was dragged. The blood coming out of Jake's ear indicates, out of his ear and then down the back of his head, indicates his head moved while it was bleeding. And only the crime scene guys can see stuff like this, but now that he's pointed it out to us, we can see it too. This blanket, it's got quilting pattern on it. You know where that quilting pattern is? Right there, in that blood. In that drag. What does that mean? It means that blanket was here, and was pulled here. Quick enough where that blood couldn't pool right there. Does that happen when a person jumps on the bed to get a dog? Is that reasonable? Is that unreasonable? This is also a very telling photograph. That same white blanket, you guys see that? Look at how it's shaped. You heard Sergeant Billsby testify. That blanket was pulled. That blanket was dragged. Look at the shape of it. It's bunched up in the, this is common sense. It's bunched up in the back there. It's a triangle. You had to pull it. You had to pull it. The tightness of the sheet right here. We all have beds. We all can make the beds. Side note, never been able to fold a fitted sheet in my life. I don't know that I'll ever learn. But this fitted sheet here, it's tight. Here on the edge. Loose up there. Bunched up there. Tight right there. Jake was dragged. It pulled that sheet tight. You heard Sergeant Billsby testify that Jake's clothing appears to have been twisted. It's twisted like Jake's body had been turned. You see the blood pool there. And you heard that only happens when blood pools. Was Jake's head there? Is that reasonable? Is that unreasonable? Was his body then pulled and turned where his clothes ripple like that? Is that reasonable? Is that unreasonable? Oh, and the bath mat on top of the blanket. I don't think I even need to point anything else out other than that. The bath mat on the blanket, and the blanket was pulled? What does that mean? Could it be someone didn't want to get blood on him? Could it mean they needed somewhere to kneel down while they were trying to pull that blanket or pull that body? Is that reasonable? Or is that unreasonable? Common sense is what we're talking about. Jake's legs and feet were straight down. You can see that. You don't have to have an expert say his knees were straight and his feet were straight. You can see that. Look at his feet. His legs and his feet. Does that happen if somebody jumps on a bed to get the chihuahua? And I want you to look at Jake's butt and his hips on the edge of the bed. You heard multiple times how unlikely it is that could have come to rest naturally. This is another view of the sheet. Do you see Jake's hand? That's the channeling we were talking about. That's the same arm. You see how the sheet is pulled tight here? And how his hand has grasped the sheet when he was pulled? Do you see that ripple that he was pulled? Jake was dragged backwards. Again, tape measure thing. Interesting. Ladies and gentlemen, that gun was in that drawer. Top left drawer. That drawer's pulled out in that photo. That's common sense. And you'll have these photos with you. Take a look at that drawer. It's pulled out. It's where the gun was kept. You heard from everyone that the gun was fired at an indeterminate range. We know it wasn't up against his head. Gun pulled out of that drawer. Jake shot from right there in front of that dresser. Is that reasonable? Is that unreasonable? Jake's death was not a suicide. The state ruled it out because the evidence rules it out. The evidence rules it out. You know what the evidence also shows? Every element of murder is met. So every crime has certain components. Now, I won't lecture you. This is just the nerd stuff that us lawyers like to talk about. So you have fundamentals of a crime. You have means, opportunity, motive. I'm sure you guys have seen TV. You probably means, opportunity, motive, right? Means here, pretty easy. Handgun. Jake's Gen 3 45 caliber Glock 30. Opportunity. Jake was all alone with Susan. After he had coffee with his son to make their plans for the day, Jake and Susan were all alone for approximately 40 minutes. 40 minutes while Will was gone. 40 minutes. And you hear on the 911 call, the moment Will gets back to the house. It's before first responders had gotten there, because Susan's still on the phone with 911. It's before the DCP got there. It's well before the EMS got there. That call was at approximately 11:04. That's when Will gets back. Did you hear Will testify about what he saw that day? This was a traumatized 17-year-old who the defense wants to point out, well, he didn't tell the officers. This was a traumatized 17-year-old minutes after learning his dad was dead. They were going to go to the racetrack. Will was pumped. His dad was pumped. But you can hear that for yourself. Again, 1975 Firebird. Cool car. Motive. And this is the stuff the defense doesn't like us talking about because they put themselves in a box they can't get out of. Insurance money. You heard Susan's own statement. She got paid. When Jake died, she got paid. Finances weren't looking good. She'd expressed that she was unhappy with Jake's finances. Jake's dead. She gets paid. Property. She emptied the house out. She took all the stuff, all the furniture. She took the Jeep. She took it. Loss of consortium. Consortium, tough word. Loss of a sex life. Loss of companionship. You heard her own statement that she gave. She was unhappy with their sex life. There was testimony about Jake being on testosterone. There's also testimony about roughly when that happened. Do you guys remember when the defendant and Jake met? You've heard it a few times. August, September 2012. Married in March of 2013. You heard testimony that Jake went on the testosterone in that time frame. What does the evidence show in this case about Susan's mindset? She wasn't satisfied with his financial situation. She took control of everything Jake had. She told people she was a nurse. You heard her own statement. She's not a certified nurse anywhere. Then she boxed herself in. Where'd you go to school? It was online. What school? I don't remember. Is that reasonable? She told Douglas Buckner, who sat right here, she was a nurse at Phoebe Putney. Phoebe's got a lot of nurses. That's a big hospital. And they're everywhere. She wasn't a nurse. She told you that in her statement herself. She messaged Douglas Buckner. You heard about that. You heard it straight from Douglas Buckner. She offered to sell Jake's tools. I don't know if any of you are mechanics, right? You heard something about a Snap-on toolbox, right? Snap-on, very expensive brand of stuff. Lifetime warranty on all the stuff. She wanted to sell it to Buckner. We'll talk a little bit more about that in a second. Right here. You heard Mr. Buckner say he didn't know why Mr. Jake wanted to sell that stuff. He didn't know if Mr. Jake wanted to sell that stuff. Snap-on, lifetime brand, expensive stuff. Meant a lot to him. Jake wouldn't be around much longer. The day after Jake was shot, the day after, she changed the locks on the house. Because it apparently needed to be, you heard that needed to be done from some time. They're worried about her safety. The day after her husband was shot? You heard Jake's coworkers testify in this case. She called one of them and volunteered. I didn't kill him. I didn't kill him. Is that reasonable? Is that unreasonable? Jake's family and his ex-wife, Miss Betty, were left to hold a memorial service for Jake because Susan told her Jake didn't have any family or friends. And I asked Miss Betty, did Jake have family? He absolutely had family. The defense wants to make this a case about unmanageable grief. Rachel couldn't accept that her dad shot himself. This isn't a story about unmanageable grief. This is a story about the resilience of a family that knew an injustice happened and saw it through to the end. 12 years! This is a story. This is the fact that family is strong. That family knew Jake so well. Will, his son, was the light of his life. He had plans with him that day. Susan didn't have any family, or Jake didn't have any family or friends. I beg to differ. She couldn't leave it alone. A few days after Jake died, she posted a thing on Facebook. I think she updated her cover photo and had a message for it. Designed to not only intimidate, but to antagonize that same family. Because they knew Jake didn't take his own life. To whom it may concern, I do not play games and do not tolerate any drama or negativity that comes my way. I am way too smart for all this. Wrong version of 2, by the way. Should have a second O there. So please back off, or I will have no choice but to take necessary legal action. I am way too grown up, again, too smart, she's missing an O there, to spend my last days here on earth in jail. Is that reasonable? Is that unreasonable? Again, we're left to talk about what does the evidence show. Defense says we haven't put up any witnesses to talk about what happened. What does the evidence show? June 26th, 2 days before Jake died. It's a big blow up. She accused Jake of cheating on her. And you heard Will testify that his dad had his head. Well, while Susan was berating him, Will had his head in his hands. Jake had his head in his hands. He looked at Will and he smirked. You heard that from Will. Between June 26th and 2014, or between June 26th and June 28th, we don't really have a lot of information about what that relationship was like, other than a concerned son who wanted to know if his dad was going to get divorced. 17-year-old son. They wanted him to be an expert in relationships. He just wanted to know, because what he saw concerned him. On June 26th, that concerned him. Jake was going to go to the racetrack with Will that day, hours after he was shot. And baby, that Firebird was going to run for the first time in a long time. Jake was pumped. He wasn't sad that his car was gone. He was excited that car was going to run again. When Will was getting coffee with his dad that day, that morning, before he left to go pick up his girlfriend in that 40-minute window, he didn't see Susan in the house. He didn't know if Susan knew he was there or not. But you heard Susan's testimony. Will wasn't there. Because she knew Will had left the house. Like the defense, I encourage you to listen to this 911 call. Ladies and gentlemen, it's common sense. We're here in Dougherty County. We're here in Albany. I can say this. It's crazy. It's crazy. She claimed him shot himself, and I'm gonna play a little clip on the next several slides. She claimed he shot himself. Jake never showed any suicidal ideations. Not even to his doctor. You heard his doctor testify that if Jake had had that, he would refer him to a psychiatrist. And this psychiatrist, this phantom psychiatrist, was a referral during one hospital visit. He was not on any psychotic meds. You heard Dr. Houston, in the South we say Houston, that Jake was only on Prozac. He was off of any antipsychotic meds in June of 2014. He was off off of all of that. Ladies and
Your Honor,
gentlemen,
I'm going to object. That's a mischaracterization of the testimony. The doctor did not say he was off all medications other than Prozac.
off the psychotic medication. And he did say he was only on Prozac.
Took him off the antipsychotic.
The jury will remember the testimony, Your Honor.
Jury, I will objection. You all will remember what was said and what was not said.
Ladies and gentlemen, I'm as transparent as they come. As you get to know me, as you've seen me throughout this trial, I'm as transparent as they come. Ladies and gentlemen, I take an antidepressant every day. That mean I'm suicidal? No, of course not. You'll find other people in this courthouse right now probably taking an antidepressant. I take Zoloft, by the way. I'm not Prozac. I take Zoloft, by the way. Jake was a happy-go-lucky guy. Happy-go-lucky dude and always had a smile on his face. He loved his life. He loved his family. He loved his friends. That's obvious. Again, boxing herself in with this 911 call. She claims she didn't touch anything.
I didn't know what to do.
You heard her statement, right? I jumped on the bed to get my chihuahua, my dog. What kind of dog was it? Chihuahua. Direct quote. She jumped on the bed to get her dog out of the blood. You saw that stain just like I did. Was that a chihuahua on the bed? Is that reasonable? Self-proclaimed nurse. Husband just shot himself. She didn't even check on him. Checked on the dog. Apparently. You'll have these pictures with you. I don't blame you if you don't want to examine them closely. I know you're probably tired of looking at them. You see paw prints on that bed? If you've ever had a chihuahua or any kind of small dog, pretty active little guys. I ask where? You saw a picture of the floor. You see any bloody paw prints there? See any bloody footprints from the lady who jumped on the bed to get her dog out of the blood? They want to point the finger at the traumatized 17-year-old kid minutes after his dad died for not reporting everything to the police. He was with the only other adult at the house who was talking to the police. This is a scared 17-year-old living out, watching the most unfortunate and saddest day of his life unfold. He thought his stepmom was going to handle it. He saw blood on her hand. "911 call. You hear when Will arrives. You hear it. So that's before the police got there. Before the EMS got there. He saw the police arrive first. During her sworn statement, she couldn't affirmatively tell you she didn't have blood on her hand. Could have been there. Again, boxing herself in. For someone who jumped on the bed to get her dog, there's no blood on her clothes. That reasonable? that unreasonable? You heard that she was made up, had her makeup on. I don't know anything about that. That's all I can tell you. She was made up. Her hair was done. You heard that. No one. You heard this testimony for yourselves. No one went in the bedroom between the Doherty County Police getting there and taking the photos. Deputy Adams, 12 years ago. This was 12 years ago. Couldn't remember if EMS was maybe at the property. He knows they weren't in the room. You heard testimony of what it would look like if they were in the room. EMS personnel apparently leave their stuff everywhere. Who can blame them? Their job is very stressful. I couldn't do it. But they would have left behind their trash, their bandage wrappers. You heard that from a guy who is lead investigator at 3,300 crime scenes. And that's here in Doherty County, by the way. This Chihuahua dog on the bed, jumping on the bed thing, it only came out years after 2014. There's no testimony that anybody else even saw a dog there. The testimonies, no one else testified that they saw a dog there. So I ask you, is that reasonable? Is that unreasonable? The defense admitted this was weird, and I agree. Again, we're in Doherty County. It's crazy.
I thought he was gay. I didn't know this.
Minutes after Jake was shot.
I thought he was gay. I didn't know this.
That sound like a woman in grief? Does that sound like a woman covering up her tracks? Question for you. Not only did she say it on the 911 call, she told the police that. Jake shot himself because he was gay. What? I'm not sure how many times we had to ask this to people. I'm really not sure. Not a single person. Not a single person. Not his wife of 26 years. Not his son. Not his daughter. Not his sister. Not the people he saw at work every day. Not a single one said he was gay. Every single one of them said Jake wasn't gay. In fact, there's a pretty funny statement about something Jake may have said to a coworker. I won't repeat it, but you know, I think you guys remember the statement about what he said at work.
I thought he was gay. I didn't know this.
Craziest one. She found out Jake had all these transmitted diseases. When a disease is transmitted, wouldn't the person with whom that person is having intercourse also have a transmitted disease, right? Reasonable question.
He was gay. And then he told me to say this is transmitted disease. It was like,
You heard her statement right here. I meant to say PTSD. You transmit that? That reasonable? That unreasonable? You heard from his doctor, Dr. Houston. Jake wasn't suffering from any or being treated for any sexually transmitted disease. Anxiety, depression, sure. I mean, in this day and age, who's not? ladies and gentlemen, defendant put herself in a box she wants to get out of. Jake never saw active combat. Never told us why she thought he might have PTSD. From her mouth to our ears, she didn't allow anybody else in that room.
Don't go in the room.
She-
Not going at that room. Nobody.
She didn't touch anything.
Go in the room. Not going at that room. Nobody. You hear me?
Do you guys hear that voice in the background saying yes? 17-year-old who just found out his dad was dead. She said Jake suffered so much he couldn't take it anymore. Jake, who didn't have family or friends, apparently. Again, beg to differ. Jake wanted to get back to work. I'm sure there are a few of us who feel this way, and I mean few. Jake loved his job. He liked going to work. He liked his coworkers. He liked hanging out with them. Again, I love hearing Mr. Edwards when he's able to talk and argue and present witnesses. He said yesterday, she literally loved him to death. That wasn't just him saying it.
Janet, I really love this man. I love it to death. Janet, I really love this man. I love it to death.
She admitted in her statement that you heard right there. History of police calls made to the house by them both. You heard her statement said they really only argued the one time, or she only accused him of cheating the one time. Is that reasonable? Is that unreasonable? You heard from Dr. Houston, and I won't belabor this because the defense may stand up. Jake managed his health well. He managed his health well. You heard that from him. That's his PCP, his primary care physician. Jake managed his health well. Yes, he had 2 heart attacks. But Jake managed his health well. So this is when we get into the meat of exactly of what you're being asked to do. So the first charge is malice murder. Susan Embert committed malice murder. Under Georgia law, murder. We don't have like the first degree or second degree. We have murder, and then we have felony murder, which I'll talk about in a second. Murder is when a defendant unlawfully kills a human being with malice aforethought, either express or implied, and I'll talk about that, and causes the death of another person. Express malice is that you deliberately did it. Implied malice, where a killing shows an abandoned and malignant heart. They said we presented no evidence, no witnesses, testified to murder. Evidence shows you all you need to see. Let's talk about premeditation. I'm sure you guys watch crime shows. That means you decided beforehand to do something. There's no particular time frame in which you had to make that decision to do something. You can just decide to do it. Premeditation can be formed in the blink of an eye. It can be an impulse. Premeditation can be formed in the blink of an eye. You don't have to stew on it for a month, stew on it for a year. You don't have to. In an instant, malice can be formed. And a mortal blow struck. We talked about motive. That's what causes somebody to do something. Technical language is moves the will and induces the action, but it makes you do something. We're not required to prove it, but in this case, we're seeking justice. We think it's important. Susan Embert made a decision. She did. She's going to take Jake Embert out. And she got paid. She thought it'd be paid more. She got paid. That came from her. She told you she got paid. Right there. Her statement. You heard Mr. Edwards yesterday talk about foreclosure and when a house is foreclosed. You heard Will testify that Susan got the mail. I think it's common sense how foreclosure notices get sent. They come through the mail. If you don't answer it through the mail, do you guys know what happens? Put it on your daggone door. Right? Like, that's common sense. That's the stuff we all know. Again, express malice is the intent to kill. Implied malice is the intent to do something deadly, like firing a gun, knowing that it is deadly, and not caring about the results. Again, I love that phrase. Abandoned and malignant heart. That's what our government, our legislature in Atlanta, our government, again, that's by the people, for the people, to protect the people. Susan Embert presented that express malice before Jake was killed. Jake won't be around much longer. What? She presented implied malice when she shot him in the head. Implied malice. She shot him in the head. Check. Caused the death of another person. Ladies and gentlemen, Jake's dead. Check. Susan Embert is guilty of malice murder. Check. Next charge was aggravated assault. Assault generally is when a person is put in apprehension. They're scared of immediately receiving a violent injury. That's assault. That's general assault. Aggravated assault is committed when the person assaults another, puts them in that reasonable fear of harm with the intent to murder, or with a deadly weapon. That's aggravated assault. The gun is what makes it aggravated. Deadly weapon, I don't think I have to belabor this. Gun. Pew. Check. Another person. Jake Embert was a person. Jake Embert wasn't only a person. Jake Embert was a father. Jake Embert was a son. Jake Embert was a brother. Jake Embert was a dad. Check. Serious bodily injury. Jake got shot in the head. Check. Susan Embert is guilty of aggravated assault with the gun, with the deadly weapon. felony murder. So this is kind of confusing unless you study this a lot. So you hear the terms like felony murder versus murder, right? So murder is the malice murder that we talked about, the express or implied malice. Felony murder is when the murder happens during the commission of a felony. So imagine a felony, any felony you want, put it in brackets. If during the commission of that felony, like aggravated assault, defendant unlawfully kills a human being and causes the death of another, kill someone while engaged in felony murder. That's why it's called felony murder. It doesn't mean like murder that's a felony and there's murder that's not a felony. That's not what it means. I know it's confusing, but that's not what it means. It just means the murder happened during the commission of the felony. And the judge will tell you this too. You'll get a bunch of instructions from her, and it's important that you listen because she tells you everything you need to know before you start your deliberations. But motive, like I said, it's not an element of the offense of felony murder. You don't have to have motive in that case. You don't have to prove motive at all. But with felony murder, you just have to have the felony, and somebody dies in the commission of that felony. Somebody's killed in the commission of it. That's all it is. Doesn't even require malice or the intent to kill. You can intend to hit somebody with a baseball bat in the hip, but if they fall and hit their head and die, it could be felony murder. Could be. Susan Embert made that aggravated assault, that felony on Jake Embert. Check. Again, Jake Embert died during the commission of that felony. Check. Even if she didn't mean for him to die, like let's assume she didn't even mean for him to die, or it was an accident when she shot him, it's still felony murder. Susan Embert is guilty of felony murder. Possession of a firearm in the commission of a crime. It pretty much is exactly what it sounds like. That the person has within arm's reach of her person a firearm during the commission of any crime against or even involving another person. Possession of a crime during the commission. Possession of a firearm during the commission of a crime. Firearm in arm's reach. Gun's in the drawer. Drawer was out. Check. When she shot Jake, did she have the gun? Check. Susan Embert's guilty. Possession of a firearm during the commission of a crime. Now the judge, like I said, she's going to give you instructions. She's going to read. It's going to seem lengthy, but it's critical that you listen because that's the information that you will have and will have to have, and the instructions that you'll have when you go to deliberate. She's going to tell you how reasonable doubt is defined. The defense tried to tell you too, but I'm going to tell you exactly what reasonable doubt is. It's exactly what it says. Doubt for which you can give a reason. And that doubt is one of an honest and impartial juror honestly seeking the truth. Ladies and gentlemen, we've been together a long time. And I told you from the very beginning, all we'll ever ask for you to do is speak the truth. Using your common sense and your reason. Now these are the ideas that were proffered to you that aren't reasonable doubt. Reasonable doubt is not absolute certainty beyond all doubt. It's not to prove something beyond a shadow of a doubt. It's not seeking to be more sure. That's not what reasonable doubt is. It's not seeking to be more sure. It's not conjecture about what if she's innocent in light of all the evidence indicating guilt. It's not what it is. Stuff about wrongful convictions, I mean, that's not something for you guys to worry about today. If it's in this context. And yes, the state cares when a person is wrongfully put behind bars. And when I say the state, the government, I mean me. I mean Mr. Edwards. I mean Mr. Terry. We don't care. I get to go home and not think about it again. Reasonable doubt is not requiring that everything that is possible to be proven must be proven. That's not what it is. Ladies and gentlemen, there were 2 people in the house when that shot went off. One's dead. The other one's right there. Requiring that everything that is possible to be proven must be proven, that's not reasonable doubt. It's not searching for doubt. We never want you to do anything other than search for the truth. You know what that is. You know what that is. You. Your verdict should be based on the facts that you've heard in here, the law, which the judge will give you, and most importantly, and I think everybody needs more of it, common sense. You don't have to throw that away or check it at the door. Citizens in this community, that's who serves on juries here in Dougherty County. That's all we need is our common sense. Don't be so overwhelmed by legal jargon that you may be confusing, that you just don't know what to do. Because, ladies and gentlemen, you do know what to do. Citizens in this community are the ones who make that judgment, that make that decision, using what they got. Not what the defense wants you to have, what you got. Common sense. You see things as they really are. You do. As they really are, and to do things as they should be done. That's what it is. Cling to the things in which there is no doubt. The evidence, no doubt about that. It's the defense's job, as you heard from Mr. Edwards, rabbit trails, I think was the phrase he used, or red herrings, stuff to try to confuse you so you think, you spend more time thinking on that than you think about what happened. Like the date on the death certificate that was put on there by the Vital Records office in Atlanta, the August date. Coroners aren't perfect. You heard the defense's witness when I asked him, sir. Coroner's perfect? No. Were you perfect when you were a coroner? No. That was their guy. It's your duty. Don't focus on passion. Don't focus on conjecture. Don't focus on sentiment. Don't focus on any prejudice. Don't focus on penalty and punishment. And don't focus on any sympathy. You focus on the documents that you'll have with you, the testimony of witnesses that you heard, the credibility of witnesses that you determine, the photos that you will have, the elements of the crime that the judge will give you, the evidence. It's an injustice. It is injustice to fail to convict a person who is guilty. I think everyone in this courtroom agrees. Anyone who violates the law has to be held responsible. That's the fundamental element of our justice system. America's coming up on its 250th birthday. Happy birthday, America. We have to hold people responsible for what they do. You remember when I gave the opening statement to you guys? Her actions have to have consequences. Her actions must have consequences. Just because the crime happened in 2014 doesn't mean she can evade justice now in 2026. And just because the case was assembled by a private investigator doesn't make what she did any less of a crime. Law enforcement could have been better. I know that. You know that. Coroner's investigation originally could have been better. I know that. You know that. But they're not on trial here. Her conduct is. Her statements are. The evidence is. Mr. Edwards and I talked about this. This is, I think, the most concise way to present everything to you. This is the path to proving murder. The wall. Jake's body was moved. Gun was moved. This is a demise. It's fake, it's plastic. It's not even the same model of the gun, but use my non-dominant hand. Hold on. How does that happen? Gun planted, fingers outside the trigger guard, fingers on the grip. Fingers on the grip. Jake didn't have any blood spatter on his hand, consistent with a self-inflicted gunshot wound. That wasn't there. No, the residue on the gun that was visible was trace only, Q-tip only. Bedding shows the body being moved, shows the path. Blood spots on the bed show that he was moved. The incidentals at the scene, the blanket, the bath mat, showed that scene was staged, manipulated. Physical findings in the bedroom consistent with Susan being the shooter. Jake was shot in the right side of his head. Gun in Jake's left hand. Susan had blood on between her third and fourth knuckle, ring finger. But told 911, I didn't touch anything. You heard that. The explanation of why Jake shot himself, that he was gay, that he had sexually or transmitted diseases, not true. House was in foreclosure, debt was mounting, she wasn't happy with the finances. Told a witness that Jake would not be around much longer. Had 40 minutes to carry it out. Jake didn't show any signs of being suicidal.
I'm sorry to interrupt, Your Honor. I have to object to the demonstrative. It says the gun was in Jake's left hand. The gun was in Jake's right hand.
Jake's right hand. Sorry. Gun was not in Jake's left hand. Excited about going to the race again. Constantly accusing Jake of cheating. Not happy about the Jake's finances. Had the victim cremated within 24 hours. Changed the locks. Took the stuff. Gave different events of what happened. She was in the shower doing her hair. She went to get her vapor cigarette. Statements about the crime. This is all we're ever going to ask. It's all that you ever should do. Return a verdict that speaks the truth. Jake Embert didn't choose to end his life in his house, on his bed, with his son coming back to go see that Firebird race again. She chose for him. So there's this concept called the empty chair defense. It said if you've got two chairs, you've got the person accused of doing something in one, and you've got an empty chair in the other. And you ask who did it. You always point to the empty chair. Tried to say Jay committed suicide. That didn't work. Tried to say that law enforcement may have moved the body. And when that didn't work, tried to say the EMS moved the body. When that didn't work, they brought their expert up. Said that Jake may have moved himself because bodies can convulse. Same expert said We don't know what happened. Ladies and gentlemen, this chair is empty. That one is not. There were 2 people in the house that day. Jake, Susan Embert. Ladies and gentlemen, decision's totally up to you. Ball's in your court. As it should be. That's how this is supposed to work. This defendant is guilty. Your Honor, that concludes the state's closing statement.